Your turn. There might be duplicates in there, right? Just ones with the stickers go back.
I'm not a lawyer. Once again, like I stated earlier, forced to do this myself. People might say otherwise. It's the truth. I literally was trying to get people to fight my case for me and fight arguments that I had. They wanted me to take plea deals, so because I didn't take plea deals, they told me to start saying that the last attorney that I had, they quit. Right in front of the judge, I brought him in. I said, "Can you stay on record while you're quitting?" He couldn't come up with a reason. So that's just my thing of representing myself and collecting all the facts that I try to collect. The fact of the matter is, we have me and God. That's what I say. He grasped into me. I didn't, that alcohol bottle, I don't know how it got in the car. That's simple. People might not believe that, but it's the truth. I didn't have an alcohol bottle. I literally pulled up the beer that I drank. I'm not able to admit it into evidence. So it's like I don't know the rules of everything like this. But in this context, I've separated my defenses into sections. One of the sections is with no confession. I did confess to drinking alcohol. I said what I drank. Whether they believe it or not, that's up to them. But that's what I said. No witness operation. Regardless if they believe what I said was true or not, in any situation, if they arrive on the scene where there are two cars disabled, you never witnessed any operation. So it's simple. You didn't witness me operating a vehicle, and then you come up with this test. Okay, you're coming up with this calculation of this test. Like I said, there's some mishandling of that test, period. Somewhere down the line of taking the test or performing the test or whatever the case may be, I believe that there was mishandling on somebody's part, or it could have been a mechanical issue. Those things happen. You cannot leave that and just say that can't happen. You also cannot say that these people cannot, human mistakes, you cannot say that these people can't make mistakes. It's just, I mean, we heard testimonies being said that just certain people were unblemished. I don't even understand that concept. I don't believe it. Just like they don't believe what I say. I don't believe what they said. Members of the jury, once again, I'd like to thank you for your service today. Today was a case about numbers. Upwards of 90% of court cases in the U.S. get determined in plea deals, meaning that over 90% of the time, whether guilty or not guilty, defendants get persuaded to take plea deals. I don't know the reason why each of these defendants on case-by-case basis does this, but I didn't choose to do so in this matter. I chose to fight my case because I know I'm innocent, and it is my right to not only have an impartial and unbiased jury, but to be presumed innocent until proven guilty beyond all reasonable doubt. I use the word a lot in my questioning today for a reason. That word was fair. The definition of reasonable is fair. And if you pull it up, you'll see. The word fair is in the definition of reasonable. And out of the mouths of the government officials, I can tell multiple questions. Out of the mouths of multiple government officials that handled this case, there are a lot of fair doubts and or a lot of reasonable doubts in this case. One of those reasonable doubts is, given the fact that there was no witness operation, you can't say that that there was any impaired driving on my part, whether you believe what I said or not. Another reasonable doubt is the fact that the blood alcohol levels are not concrete. They're not concrete. They are subjective to testing and handling of testing. Even regardless of the blood being mine or not, even if it was mine, a simple mishap, a simple mishandlement can change the integrity of the test, whether the prosecution wants to let you all know that or not. There's also a lot of footage in this video. We pulled up a lot of it. I think I said this at the end. There was a lot of video that wasn't able to be seen in this hearing because the prosecution had access to all of it. I got to go and I literally just seen this video today, and they showed me what they wanted to show me, and I took little bits and pieces out of it. Even though I told them I drank another reasonable doubt is the fact, even though I told them that I drank a non-alcoholic beer that day, which was the truth, they still chose to believe that I drank an alcoholic beverage. But even if that were the case, you don't know when the drinking took place, so you don't know if my body was being affected by alcohol or anything else, or if my levels were at a certain level or not. There were a bunch of ifs, and that is not suitable for a criminal case where you are trying to prove a defendant guilty beyond a reasonable doubt. I'm not coming with a crazy argument that I'm a sovereign citizen or that the laws don't apply to me or that I didn't drive at all. I'm saying, once again, that I didn't drink alcohol and I didn't cause the accident. The officers made mistakes that are obvious. One of those mistakes, they mischarged me with something that I never was charged with. And I wrote this while I was in here. And the excuse for that was, it was in good faith. While you're trying to accuse me of something and saying that something that I did was untrue. Why do they get the opportunity to say that something that I did was untrue or something that I said was untrue? But when I bring up something that they did that was wrong, they can just say, oh, it was in good faith. Or if I say, oh, you made a mistake in this or that, well, I try my best to do it every time. It's like, you can't put yourself on this podium as to be this perfect person and then turn around and just put me like, oh, you are what we say you are. And what you say doesn't matter. There is a possibility that what I said could have happened. They weren't there to witness otherwise. So, my last point. There was a lot. These are vital. They also said our cause of accident, which is not true. These are vital mistakes in the case and should not be disregarded, especially when a bulk of his case and its results rely on the handlers not making mistakes. There is a lot in that arrest video that is not shown. One of those is that I told the officer I just wanted to go get medical treatment so I can get my son. I clearly said in the video I didn't drink anything. Earlier in my opening statement, I stated that I drank a Corona beer. Earlier that day, I pulled up. Wait a minute. No, I said I drank a Corona beer earlier that day. I pulled up the beer. I did that in here, but I can't admit it to you all. I can't show you all through my phone. I wish I would have had time. I would have brought a beer in here to show you what I drank. That is a beer. That is one of the beers that me and my friends drink. We drink non-alcoholic Heineken beers and non-alcoholic Corona beers from time to time. These are for me and my friends that do not drink or smoke. I try my best to keep my shape and keep my health. This is why I chose not to drink alcohol. One of the other factors is the crime scene. Once again, regardless of what he's talking about. He was saying in the video, I chased him around the road. That's crazy. I literally, like I said, I was driving this way. You see the cars in the video. We were both on the side of the road. He said I chased him around and he went this way and I went that way. I literally was going straight down the road. He came this way. I veered on to the side and he came and smacked me. You'll see the damage of the the damage of the vehicles were right in those places. The placement of the vehicles were right in those places. I mean, they're just believing whatever he says. He also said that he was hurt. That just went away. Big video. He's literally moving around and doing all this stuff and talking crazy. And it's just, it's not believable. But to say that what I'm saying is it's not believable, it's not fair. It's not fair in a court of law. We gotta prove me innocent beyond a reasonable doubt. I was instructed that I couldn't give commentary during the video play, but you can see in the video that the cars, I was instructed that I couldn't give commentary during the video, but you can see in the video the cars on my side of the road. You also see that he's perfectly fine. But if you see earlier in the police encounter, he said that I chased him and this and that. He said the prosecution said that that doesn't matter, none of that matters. That plays a lot into everything is being said, because this guy said I crashed into him. That's called impaired driving. He's saying I did some type of crazy driving. I did this. It's not true. It does matter. And if you see the earlier points of that night, he was doing all this lying, saying his hand was hurt and I crashed. And it's just everything that he said was a lie. You would have seen it if you would have seen all the video, but I wasn't able to get a hold of the video and dissect it for myself. My history plays a part. I'm 34 years old. I've never been convicted of DUI, regardless of what he said in his report. I never was convicted of DUI before. I'm 34 years old. That should say enough about my work. I've been working since I was 13 years old, been paying taxes. I work as an armed security guard, different sites. I mean, I don't know, what people, when they see people, you might think, oh, he's in court, he's a criminal, or he's whatever you might think. I'm not a criminal. I go to work. I got 2 kids. I take care of kids that I even thought was mine that ends up not even being mine. I'm a good person. That should count for something. I have never been convicted of DUI because I don't drive drunk. So this is a crazy situation, a lot of crazy facts, but at the end of the day, there is no concrete evidence to convict me beyond reasonable doubt. And as far as that bottle, once again, you didn't pull me over. I didn't. That has to be convicted. Operating a car with a bottle, open bottle in a car. They didn't pull me over. If they would have pulled me over and I had a bottle of liquor in the car, then you would be able to say, "Hey, you had that bottle in the car. They pulled you over." But for them to arrive on the scene, all this stuff is going on. You see that those people that were with him wasn't there with him when it first happened. It's just him. That's why you got him standing there trying to talk to that guy while the officer there trying to put on a show, saying, "Oh yeah, this is what happened," because that guy wasn't there. He did all these calls. He made all these calls, but he never called the police. Just like I said in my opening statement, you see that in that part of the video. He never called the police. So it's like you say all this stuff, but why didn't you call the police? Why did somebody else have to call the police, like the officer said? Somebody bystander came and called the police and said that it happened. So it's so much, like I said, that you need to put in your minds to say reasonable doubt. And that's it.
Thank you, Mr. Lee. Mr. Greco.
Briefly, the police didn't call the police. Regardless of all of the things that you're hearing about from the defense, about throwing stuff out there, this is a very simple case, right? Reasonable doubt is not about what's possible. It's about what's reasonable for you to consider. And reasonable doubt based upon your common experience and the evidence that is presented to you today. And based upon the evidence that you have today, you have more than enough beyond a reasonable doubt to convict Mr. Lee of operating while intoxicated. Just a couple of things to clear up in your mind, because I had experience with jurors and all the things that they think about with things that were said, okay? And we're giving Mr. Lee a little bit of leeway. with respect to the discovery, the reports, and all of the videos, they were emailed to Mr. Lee's attorney on October 7th. When he terminated that attorney, they were emailed directly to Mr. Lee on November 21st, then emailed again on April 4th, and then via email by me on the emails that he's been sending me, I offered, if he was having trouble opening the link, that on 2 o'clock this past Friday, there was a zip drive, thumb drive at the front desk of the police department for him to come and get the videos. Despite all of that, during this time, we gave him an opportunity to look at more fully some of the videos, and he wanted to play it for some reason. I'm not sure exactly why. All it does is give the other driver's account of what happened, which this is not about. There was a car accident that was there. He was not cited for any reckless driving or going across the other lane because there was no witnesses to it. All we had was an accident with one driver who appeared to be intoxicated, not guilty of it, but based upon probable cause, these officers were able to get a search warrant and show that there was an unlawful bodily alcohol content in Mr. Lee's body that night while he was operating the vehicle. Thank you, Barry.
All right, folks, now it's closing or it's final arguments time. So if you want to follow along on your tablet, if you go to that submenu, click on final instructions. Mine just went away. There it is. All right, final instructions, page 1, duties of judge and jury. You there? Let me know when you're all there. Or if you're not going there, just tell me you're not to wait for you. Everybody good? We're good?
I'm not even right at the point. I love to say videos.
No. You only get one shot at a closing argument.
Yeah. Oh,
Now we're there? Okay. I lost mine. There we go. All right. Page 1 under final instructions. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. Lawyers' questions to the witnesses and my questions to witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness' disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how a witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remember. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think a witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Moving into page 4, elements of the crime. The defendant is charged with the crime of operating a motor vehicle while intoxicated with an unlawful bodily alcohol level. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. To operate means to drive or have actual physical control of the vehicle. Second, that the defendant operated the vehicle on a highway or other place open to the public or generally accessible to motor vehicles, including any designated parking area. Third, that the defendant was intoxicated. That is, the defendant operated the vehicle with a bodily alcohol level of 0.08 grams or more per 100 milliliters of blood. The defendant is also charged with having open intoxicants in the vehicle he was operating. Michigan law provides that an operator or occupant shall not transport or possess alcoholic liquor in an open or uncapped container within the passenger area of a vehicle, upon a highway, or within the passenger area of a moving vehicle in a place open to the general public, including areas designated for parking. To prove this charge, the prosecutor must prove the following elements beyond a reasonable doubt. First, that an open alcoholic liquor bottle was in the passenger area of defendant's motor vehicle. Passenger area means the area designated to seat the defendant while in operation and any area that is reasonably accessible to the defendant while in his seating position, including the glove compartment. Second, that the motor vehicle did not have a trunk or compartment separate from the passenger area, and the liquor bottle was not in a locked glove compartment or behind the last upright seat or in an area not occupied by the defendant. Page 5, the prosecutor must prove beyond a reasonable doubt that the crime occurred on or about October 5, 2023 in Romulus within Wayne County. When you go to the jury room, you will be provided with a written copy, your tablets, of the final jury instructions, which is the copy of the electronically recorded instructions will be provided. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agree on the verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer. It's not proper for you to talk directly with the judges, lawyers, or other people involved in the case. Officer Crowell, probably Officer Crowell, might be one of the other guys, will be outside the jury room all the time you're in there. Just knock on the door. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any of the reference documents or exhibits that have been admitted, ask for them. You won't have to ask. Joe's going to send those in with you. When you go to the jury room, you will be given an electronic copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. And we have prepared a verdict form listing the possible verdicts that will go in the jury room with you as well. Now I'm going out to the submenu to the evidence instructions. Give you a chance to get there. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider what such an out-of-court statement against the defendant, you guys okay? Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and meant to do so. So back to the submenu. I'm going to witness instructions. We're good? You have heard testimony from a witness who has given you, actually you've heard two witnesses. Well, you didn't, the phlebotomist was not certified as an expert, correct? All right, so just the forensic scientist. All right, you've heard testimony from a witness who has given her opinion as an expert in the field of forensic science. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts she gave for her opinion and whether those facts are true. You should also think about the expert's qualifications and whether her opinion makes sense when you think about all the other evidence in the case. You've also heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. Mr. Greco, are you satisfied with the instructions as given?
Yes, ma'am.
Mr. Lee, satisfied with the instructions? Okay. All right. So folks, this is my least favorite part of the jury. If you've counted, there are 7 of you. 6 of you get to go back to make the decision. So what I've got here is my handy dandy little tin that I've had for too long. And there are numbered beads in the box corresponding to the seats that you're now in. I'm just going to randomly draw one of them out and kick one of you off the panel. 5, Mr. Droskowski, you are excused from the panel, but if you want to stick around, when this panel is done, they've reached their decision, we've shared the decision with the court, I'm going to go back and do what I call my debrief. You're still under my court order till I let you go. If you want to stick around to go back for that conversation, we'd love to have you back there because you went through the whole trial. All right. Thank you. So why don't we do this? Why don't you take them back and then Mr. Droskowski can get out.
I got
Exhibits,
copies.
jury verdict room.
I have 2 copies of
Yeah,
exhibits.
they're all, yeah, that's fine. Yeah. You've got original exhibits admitted and some copies, so that's all right. And once again, anything you leave here is going to be safe because we're not going to leave the courtroom unattended.
One for each of
There's you'll see it on the jury verdict form. It should be self-explanatory. Okay, we are officially in recess. You good? Hi, Angela.
Officer, Mr. Lee, do you guys want water?
I'm okay.
Oh, okay. If you need water, you're good.
What do you think?
Ken, did you want water or I can grab one of your pops?
Okay.
Angela, you've been here all day.
Thank you.
Did you want one?
I've been here all day, we don't all afternoon, I was at home with Al this morning,
Oh, were you?
yes, we did our docket and then like. Cause we had a motion hearing, we'll just get it.
We're live, so I don't know.
Yeah, well,
What do you mean?